Now ask counsel in 125-508, State of Kansas versus Christopher D. Kemmerly to please come forward.
May it please the court. Hope Facklick Reynolds of the Appellate Defender Office appears on behalf of Christopher Kemmerly. Chief Justice, may I please reserve 3 minutes for rebuttal?
3 minutes is granted. Thank you.
Thank you. More than 61 years ago, the Supreme Court of the United States decided the landmark case Gideon versus Wainwright, establishing a right to counsel. In that case, it proclaimed that attorneys in criminal cases are necessities, not luxuries. Nevertheless, decades later, when the state of Kansas charged Mr. Kemmerly with serious felonies, including murder, he stood at trial alone. I'd like to focus today on issue 1 in our brief, which concerns this right to counsel and how it was violated in Mr. Kemmerly's case. We raised 2 ways in which the district court erred in honoring Mr. Kemmerly's right to counsel. The first is in the advisement that took place in 2021 before the district court allowed Mr. Kemmerly to represent himself. The second was when the district court denied Mr. Kemmerly's assertion of his right to counsel mid-trial. Let's start with the advisement that happened in 2021. There's some guiding principles that I think are important to keep in mind when we discuss this issue. The first being that the responsibility of securing an advisement lies squarely with the district court. The second is that in assessing this issue, appellate courts have been clear that we indulge a presumption against the waiver of the right to counsel. That's especially important in this case because of the unique history and circumstances that it presents. A year and a half before this advisement that was at issue, Mr. Kemmerly represented himself briefly at one hearing. Prior to that self-representation, the district court provided a full advisement consistent with the low factors. But when Mr. Kemmerly changed his mind and asked for a lawyer in the same hearing mere pages later, the district court granted that request and he received the assistance of counsel at that hearing and for another year and a half before he sought to represent himself again. At that,
You agree, I'm sorry, do you agree that that first advisement in February of 2020 satisfied the requirements of state versus burden in addition to low?
the 4 factors required by state versus burden, is that what you're asking, Your Honor?
I think there were 3, but nonetheless.
Yes, Your Honor, but we're not challenging the first advisement from 2020. Our issue is solely with the second advisement that happened much later, in which the district court judge warned Mr. Kemmerly that managing discovery would be difficult, not only because it was extensive, but because he would remain incarcerated while awaiting trial, where he told Mr. Kemmerly that it would be up to him to figure out how to do what lawyers do in cases, which would be difficult because he was incarcerated during trial. He reminded him of that and made a finding that Mr. Kemmerly had already received an advisement and was experienced in the criminal legal process.
But this was after Mr. Kemmerly had already advised this very judge in this case at that time that he was familiar, didn't need another low hearing and didn't need to waste the time. So do you have any reason to think that he didn't remember everything that he had been told in February of 2020?
With respect, Justice Wilson, that's not the question. The question is whether he was reminded, whether he was provided adequate warnings and advisements before he waived that right to counsel.
With respect, that's my question.
Okay, so the record doesn't show that he doesn't understand, but the burden, to be clear, is on the state and on the court to create that record.
Do you have any reason to believe that he didn't remember everything that he had been advised in February of 2020?
No, I do not have something in the record to demonstrate a lapse in memory or that he did not recall that hearing.
So how often would he be required, do you assert that the judge has to repeat all of that each time a request to self-represent is made?
The ideal rule, I think, would be each time somebody seeks to represent themselves, each time somebody seeks to waive the important right to counsel, they should be advised of the risks involved with that decision. A helpful example might be in a plea context. When somebody enters a plea agreement, we engage in a plea colloquy each time. If that plea is later withdrawn and then a new agreement is reached, the district court does the plea colloquy anew, because the right to trial is being waived in that situation.
Do you have any case law that says that is required each time?
No, Your Honor.
So I understand the record correct. So are you suggesting then there was an initial valid advisement and proceeds pro se, but then there's a change in circumstances when he's like, well, pause, I need assistance of counsel. And then from then, I think that was for the post-trial motions, et cetera. And then you go back for retrial. And if he wants to proceed pro se again, based on that intervening circumstance of requesting assistance of counsel, there needs to be a full advisory again, anew, so to speak, because of that intervening circumstance?
Yes, Your Honor, because he requested and received assistance of counsel in the interim. What I think is especially important in the second advisement is that Mr. Kemmerly was never told, if you ask for an attorney, you might not get one. He was never told, having once changed his mind and asserted a right to counsel before, he was not reminded or told again that he might not get an attorney, that if an attorney was appointed, that attorney would not be allowed a continuance in which he or she could catch up with the case. Those were not warnings that Mr. Kemmerly received after having exercised his right to counsel in the almost year and a half between the two advisements.
Is that one of the low factors? I really just can't remember.
Um,
That if you ask for an attorney later, you may not be.
I believe so, but I'll double check.
Oh, it's okay. Continue with your argument.
Okay.
I can.
The other thing that I think is important to understand is that this appeal is from Mr. Kemmerly's second trial. At his first trial, he received ineffective assistance of counsel.
Yeah, I was going to ask you about the procedural, kind of the history of this. He had an initial trial,
Mhm.
was found guilty, or some or all the charges. Then he moved pro se for a 1507, represented himself and prevailed.
Yes, Your Honor. He had assistance of counsel in the 1507 motion alleging ineffective assistance. It's at that post-trial hearing that Justice Wall asked about that the first advisement took place because he asked to represent himself in the midst of that hearing. That's volume 59 of the record.
And he did then proceed to represent himself for the remainder of the 1507. Is that how that worked?
He only represented himself for less than 10 pages of that hearing.
Okay.
It was at the same hearing on the motion about ineffective assistance of counsel that he asked for the assistance of his attorney again.
Thank you for the clarification.
Yes. So this is the second trial at which he represented himself throughout trial. And the motion to represent himself was considered and ruled upon well before trial began. His second request for counsel came mid-trial. And this court's case law is clear that those mid-trial requests will not be granted if there's a purpose to delay or obfuscate or some other nefarious, malevolent purpose. That's not what the record suggests in this case. The record suggests confusion about whether or not Mr. Kemmerly was entitled to counsel. It requests that he was struggling to represent himself in that moment with evidentiary issues. But again, the advisement that preceded this self-representation did not provide an adequate warning for that. So this request, I think, illustrates the deficiencies with the advisement that was provided in 2021 before Mr. Kemmerly represented himself at trial.
Can you address the tension that's there between the request to represent oneself, which is guarded and protected by case law, federal case law, and our Constitution, versus the very argument you're making here today? And how does the district court weigh all of that when the warnings had been given, and the absolute right to represent himself? I mean, you might be here arguing just the opposite had it been denied, or had his request been honored and counsel been appointed. So where do you land on that, or how do we address that?
Yes, they are interrelated rights, like Your Honor is pointing out, self-representation and the right to counsel. The default, however, is the right to counsel, and we are to presume against the waiver of that right. An assertion of self-representation is a waiver of the right to counsel. It is both exercising an affirmative right and waiving a clear textual fundamental right that should be safeguarded by our system. Because of that, I think it makes the process of an advisement more important. Because those are the two rights at issue, we really need district courts to make clear findings. We need them to ask questions about the state of mind. At the advisement challenged here, there's not a single question that the district court asks about, do you remember the prior advisement? What is your mental condition like today? There are no findings of that nature that happen at the second advisement. It is cursory, it is quick. And while I understand wanting to move through things, and maybe there's an assumption that Mr. Kemmerly understood, the district court should have taken the time to be more thorough and make sure that he had weighed and considered the risks and consequences of his decision to forego counsel and represent himself on murder charges.
In going to what happened during trial, we talked about the defendant's absolute right to represent himself so long as he understands that right, and his right to counsel is knowingly and voluntarily waived. But there is persuasive authority that holds the right to then obtain counsel after that is not absolute and within the court's discretion. Would you agree that that standard should apply here?
Yes, Your Honor, we're not challenging the standard for mid-trial requests or requests to change one's mind about those rights. However, I would note that the bulk of those cases where somebody is not entitled to counsel after insisting on representing themselves have to do with a request that is made for some nefarious purpose.
Do you think that his request for counsel mid-trial was unequivocal, or was it equivocal? The state claims that it was equivocal because he said, well, because I want counsel because I'm being stonewalled. And so do we even need to decide whether it was equivocal or unequivocal?
My reading of the record is that it's a clear request for counsel, and I don't think, even if it is equivocal or made in frustration, I think that is a valid and adequate invocation of the right because of the nature of what is at stake and the nature of the right itself.
Did he have counsel representing him as standby counsel at that time?
No, Your Honor.
So it was made on the 5th day of trial.
Yes.
And persuasive authority indicates that if it is a substantial interference with the trial, that's one acceptable exercise of the court's discretion. Do you think it would have been a substantial disruption of the judicial process in this case if the court had granted his request for counsel, if it was unequivocal?
It certainly would have been disruptive, Your Honor. we're not saying that asserting a right to an attorney on day 5 of a trial is ever ideal, but that again makes the advisement more important and is another reason to illustrate the importance of that initial advisement to make sure that the decision is entered knowingly and understandingly with a full appreciation of the possible consequences and risks of proceeding alone.
The best argument that it was an abuse of discretion.
That which part was an abuse of discretion?
That the judge said, no, I'm not going to give you counsel at this point.
That it was unreasonable in the moment to deny him an attorney
And why is that?
because he should be entitled to an attorney when facing murder charges, just like every person should be entitled to an attorney when facing criminal charges of any kind, like decided in Gideon versus Wainwright.
Is that an argument that it's absolute? And not an abuse of discretion?
The abuse of discretion is the denial of the right to an attorney.
Because no matter what, because it's a murder case, he should have had counsel appointed.
Your Honor, in any criminal case, any felony criminal case, he is entitled to the assistance of counsel, which has been firmly established for 61 years. Chief Justice, I see my time has expired. May I briefly conclude? In conclusion, this court should not allow the sound of Gideon's trumpet to fall silent, but should safeguard the right to counsel in this case and in others that other generations may hear its call. Thank you.
May it please the court, Assistant District Attorney Lance Gillette on behalf of the state of Kansas. I will address issue 1 unless this court directs me otherwise. And I want to begin by saying that the state does not disagree that the right to counsel needs to be safeguarded. So does the right to self-representation. When it is asserted prior to trial, a request for self-representation that is unequivocal has to be honored so long as the defendant enters a knowing and voluntary waiver of the right to counsel. And here, the district court ensured that the defendant did enter such a waiver. I would begin by noting that this court has repeatedly held, and I cite Burden in my brief, that there is no set checklist for what's required in order to secure a knowing and voluntary waiver. And the reason for that is set forth in Burden, is that because we have to examine the circumstances in each case. Different defendants might be more capable than others. The state is of the position that the defendant in this case demonstrated himself exceptionally capable. It is in reading this trial, it's frankly a little bit difficult to imagine how much different or how much better a defense attorney could have done for him. The result was dictated by the evidence, not by his representation of himself or the district court's appropriate advisements here. I want to make one point very clear, and that is, to begin, the defendant's focus here is in his brief was only that third burden factor, whether or not the advisement was appropriate. There was some comment about whether or not the defendant was capable or competent. That's not before this court today. Burden factors 1 and 2 are not before this court. And frankly, even if they were, it is unquestionable on this record that the defendant was well aware of the charges against him, having gone through a previous jury trial, after which he himself filed a pro se motion alleging ineffective assistance of counsel that was granted based on what he alleged, frankly. The only help he got in litigating that motion was just going through the process, having that other person there to do the same things that the defendant had already alleged that he felt were failures of his initial counsel. And so I guess there was a little bit of a little bit of a question about the timeline here. And so I do want to briefly touch on that to be clear what we are talking about. Defendant was convicted his first trial in November of 2019. He filed his motion alleging ineffective assistance approximately 1 month later. Then in February of 2020, there was, as the parties agree, a full low hearing conducted. And then we had some delays with the 2020 pandemic. We get to July 8th and defendant files a motion for self-representation. He was very clear in that motion itself that he has the right to represent himself. He is mentally competent. He displayed an understanding of the law. And at that point noted only that he wanted his 1507 or his post-trial counsel as, quote, an advisor or on standby in case he wishes to continue with court-appointed counsel in the future. However, just 5 days later, he then writes to the court, quote, "Your Honor, I will be moving pro se. I will not be dissuaded from exercising that right. I do not need to have a low hearing. I will be formally waiving that. We do not need to waste record space." So what we have, and is evident even this far back in the record, is we have a defendant that frankly is trying to set traps, set pitfalls, pose catch-22s for the court. He's unequivocally asserting the right, then maybe asking for standby counsel, but then in the very next breath, he's saying, but that very same standby counsel, you know what, he's actually not doing everything I want at this point. He may be ineffective. And so then that brings us to the July 2021 hearing, whereas the state set forth in its brief, again, while there is absolutely no requirement for a specific checklist, the district court here went over roughly 70 to 80% of the low factors which were suggested in that opinion. There was no question the defendant understood everything that was going on. He even had 5 motions on file that he was ready to proceed on right away at that time. After going through all of those advisements, then we had 2 hearings in August, 3 in September, 1 in October, 4 in November, and then trial began. And at no point did defendant ever again make a request for standby counsel, appointment of counsel. He litigated this case again, just as effectively as most, if not all, defense attorneys would have.
Do you agree he did not have any standby counsel at the time of trial?
I agree. That's correct. And I would just again note that's because he made the clear and unequivocal request before trial that he wanted to represent himself pro se. And therein lies the tension that was asked about. The court doesn't have a choice. If it believes that the defendant has made a knowing and voluntary waiver based on the inquiry that it conducts, it doesn't have a choice with this pretrial. With one exception that was identified in the U.S. Supreme Court case of Ferretta, where a defendant has demonstrated that he's going to be so disruptive to proceedings that he can't be allowed to act as his own counsel. But here, this defendant gave absolutely no indication to that end. He gave only indications to the contrary, that he was a very effective advocate on his own behalf. So again, just briefly on the test, there's no question he understood the right to counsel, including appointed counsel, and then he could change his mind. He had done that during his post-trial motions. After being advised of low the first time, there's no question he knew the range of potential punishments and all of the charges against him. He'd even had the benefit of seeing his PSI, which is almost unheard of in these kinds of scenarios. The only issue was whether or not he was properly advised, and the state again asserts that he was, for all the reasons that we put in the brief. Justice Standard, you asked the question about whether he was told that if he asked for an attorney, he might not get one. That is not a low factor. That is not one of the factors that's listed in low. But then that leads right into where we end up with the second request during trial. I would note this tension between the right to self-representation and the right to counsel has to give way to some practical use. We have to be able to get cases to and through trial. And that is why once a case begins trial, once a defendant proceeds to trial pro se, the only question is whether or not the district court abused its discretion in denying a subsequent request for counsel. Here, the state would point out, as we have in our brief, the defendant's request was equivocal. I wanted to highlight actually one just factually how it came about. The defendant was he was examining his sister during, he was conducting a direct examination of her. And he began to try to wander into claims of ineffective assistance of counsel, asking her to try to comment on what his counsel in first trial had done. And the state objected. The district court sustained that objection. But notably, he was successful. And maybe he didn't even notice in the moment, but in getting his sister to testify that, look, I was only able to answer questions based on what I was asked. That's really what he was driving at. And so then there is there's a recess when the jury is taken out of the courtroom. The defendant gets upset, curses at the court. The court explains why it had ruled the way that it did. Court resumes, and the defendant makes a remark under his breath. Aside from my request for counsel, the district court asked, "I'm sorry." And he makes, again, an equivocal statement that aside from my request for counsel because I'm being stonewalled. He's upset about one issue, a non-issue. And that's why he made his request, again, evidencing him setting traps. There's no basis to assert that the district court denied this late request on the 5th day of trial evidence because it abused its discretion. It acted soundly within its discretion because it was extremely late. It was clearly intended to be disruptive, in addition to being equivocal in the first sense.
What's your best argument that it was intended?
I think there are 2 points that are worth noting. Number one, the equivocal nature of it by tying it to a dispute that he had with the court's ruling, saying, "I'm being stonewalled." Again, he's accusing the court of mistreating him when the court has done everything in its power to try to treat him fairly, to try to respect his request to represent himself. And then again, I think the timing here is telling. It happened immediately after a heated exchange. It was about a very narrow point in the trial and questions that were irrelevant, but that he was ultimately able to flesh out what he was seeking. So there was no point to it. Just to be a nuisance at that point, respectfully. Unfortunately, and I won't go too far into it, but my friend on the other side has recently, and this court recently had to deal with a similar situation when we were faced with how we get here today. This case was moved based on a letter, not filed with this court necessarily, or even filed as a motion, but making allegations against my friend on the other side. It happened within days or weeks of our first setting in this case, and it caused an issue that brings us then here today. I think, again, we can see a pattern over time with this defendant as well. So I guess I actually had 3 points to answer your question.
Would it have been disruptive?
Extremely. Again, we were on the 5th day of trial evidence in the defendant's case in chief. For a defense attorney to have tried to prepare to represent defendant effectively at that point and avoid what would have been, I think, fairly obviously an inevitable claim of ineffective assistance, they would have at a minimum needed to get up to speed on all the trial transcripts, read the voluminous discovery, probably would have needed to go back all the way to the first trial and get those transcripts as well. But I do understand that those had been prepared. It's hard to say how much time that would have taken. Defendant having lived through this trial and he still took about 7 months to prepare. And again, he knew the facts and was able to prepare in 7 months and represent himself effectively. It would have been a disruption, not only in the sense of the resources that it would have required to appoint counsel at that point, but also the incalculable amount of time that it would have required at that point. If there are no other questions, the state would stand on its brief regarding issues 2 and 3. We would simply ask that this court recognize that unfortunately we have a defendant in this case that does seek to be disruptive. That has been demonstrated repeatedly in this record. And despite that, the district court here did a sound job applying this court's precedent to make sure that the 3 burden factors were all addressed. They were all addressed. This is the defendant that knew exactly what he was doing. And despite even trying to dissuade the district court from engaging in a second low hearing, the district court pumped the brakes, did its job, and respected the defendant's right and safeguarded his right to self-representation. I ask that this court uphold defendant's convictions. Thank you very much.
May it please the court? I'm prepared to waive rebuttal unless this court has questions I can answer.
Court will take this matter under advisement.